Payment of wages. Welcome to the Fall to Ireland video series designed to support tourism and hospitality businesses in meeting your employer obligations. My name is Caroline Reedy. I'm the Managing Director of the HR Suite. In this video guide, I will address the subject of payment of wages. Key topics that I will cover are an overview of the key legislation pertaining to wages and payment of wages. Payment of wages including deductions from wages, minimum wage, the living wage and premium payments. Payment for public holidays. Notice periods when leaving employment. Legislation regarding to tips and gratuities. Sick pay from the employer and from the Department of Social Protection. The major pieces of legislation we need to consider when looking at payment of wages are the National Minimum Wage Act 2000, the Employment Miscellaneous Provisions Act 2018, the Organisation of Working Time Act 1997, and the Payment of Wages Act 1991. We will go through these in depth throughout this video, but the Employment Miscellaneous Provisions Act 2018 outlines the minimum wage for 19-year-olds, 18-year-olds and under 18-year-olds. The Organisation of Working Time Act covers Sunday premium and public holiday entitlement, and the Payment of Wages Act details deductions from wages. The purpose of all the legislation I will discuss is to ensure employees are clear on what they are being paid. It covers the breakdown in payments and all premiums and deductions. The essence of the legislation is to ensure that employees receive their entitlement to a fair wage, so let's discuss what that looks like. The national minimum wage is the minimum hourly rate of pay that employees must be paid. This rate applies to anyone aged 20 years and older. It was announced in Budget 2024 that the minimum wage and the rates for young persons will increase as of the 1st of January 2024. This will also increase the national minimum wage for under 20-year-olds. As per the Employment Miscellaneous Provisions Act, minimum wage for 19-year-olds is 90% of the national minimum wage. For 18-year-olds, it's 80%. And for under 18s, it's 70% of the national minimum wage. Next, we will look at the concept of a living wage. In principle, a living wage is intended to establish an hourly wage rate that should provide employees with sufficient income to achieve an agreed acceptable minimum standard of living. The rate of the living wage changes based on factors impacting cost of living and other economic factors. Under the Organisation of Working Time Act, employers must pay a premium for hours worked on a Sunday. This premium can be given as an allowance, an increased rate of pay, or paid time off. While there is no specific rate for this premium outlined in the legislation, the Act does state that an employee is entitled to the premium rate being paid to a comparable employee in a collective agreement in force in a similar industry or sector. A collective agreement is an agreement made by or on behalf of an employer and a representative trade union. The Sunday premium should be equivalent to the closest applicable agreement, which applies to the same or similar work under similar circumstances and which provides for a Sunday premium. Employers are also obliged to arrange that a written statement of wages or a payslip be given to every employee with every payment of wages. Every payslip must show the gross amount of wages payable to the employee and must itemise the nature and amount of each deduction. The Payment of Wages Act 1991 places an obligation on the employer to treat the information contained in a payslip with confidentiality. An employer is allowed to make the following deductions from an employee's wage. Any deduction required or authorised by law, such as PAYE, tax and PRSI. Any deduction authorised by the term of an employee's contract, such as pension contributions, uniform cleaning, health insurance contributions. Any deduction agreed to in writing in advance by the employee. This could refer to a private health insurance subscription, a social club membership, or gym membership. There are certain restrictions placed on particular deductions which arise from any act or omission of the employee, such as till shortages, or are in respect of the supply to the employee by the employer of goods or services which are necessary for the employment, for example, the provision or cleaning of uniforms. Any deduction falling into these categories must satisfy three conditions. The deduction must be provided for in the contract of employment. The amount of the deduction must be fair and reasonable, having regard to all the circumstances, including the amount of wages of the employee, and the employee must be given written details of the terms in the contract of employment governing the deduction from the wages at some time prior to the act or omission or the provision of the goods or services. Where a deduction is being made due to any act or omission of the employee, it must satisfy the following conditions. The employee must be given particulars in writing of the act or omission and the amount of the deduction at least 1 week before the deduction is made, and the deduction must be made no later than 6 months after the act or omission became known to the employer, or where it is a series of deductions, the first deduction in the series must be made within the 6-month period. Where the deduction has been made in respect of the supply to the employee by the employer of goods or services which are necessary to the employment, for example, uniforms, it should meet the following conditions. The deduction must not exceed the cost of the employer of providing the goods and services, and the deduction must not be made later than 6 months after the supply of the goods or services to the employee, or where it is a series of deductions, the first deduction in the series must be made within the 6-month period. There are several national public holidays in Ireland each year. Public holidays may commemorate a special day, for example, St. Patrick's Day on the 17th of March or Christmas Day on the 25th of December. Compensation for public holidays can often cause confusion, particularly in the hospitality sector, where most employees may be rostered to work on the public holiday and where there may be some part-time or fixed-term workers rostered to work. Part-time and casual employees who have worked a total of at least 40 hours in the 5 weeks leading up to the public holiday are entitled to the same public holiday benefit as full-time employees. Fixed-term workers should also be treated the same as permanent employees as long as they have worked 40 hours in the 5 weeks leading up to the public holiday. Compensation for public holidays can be given as a paid day off within a month of the public holiday, an additional day of annual leave, or an additional day's pay. If an employee works on the public holiday, they are entitled to be paid for the hours they work on the day and receive either an additional day's pay or an additional day's paid annual leave. If the business is closed on the public holiday and the employee would normally be rostered to work on that day, they are entitled to receive a day's pay or an additional day's paid annual leave. If the employee is not normally rostered to work on the public holiday, they are still entitled to compensation of 1/5 of their normal working week. For example, if an employee normally works Thursday, Friday and Saturday and their public holiday falls on the Monday, the employee is entitled to 1/5 of the 3 days. The Minimum Notice and Terms of Employment Act 1973 outlines the minimum notice that must be given to the employee when leaving their employment and the notice required from the employer when terminating employment. In most circumstances, the employee will work the duration of their notice period. However, there may be situations where the employer might choose to offer the employee payment in lieu of notice, meaning the employer will pay the employee for the duration of their notice period, but the employee will not be required to work. In these circumstances, the date of termination of that person's employment will be the date on which notice would have expired. Where dismissal has occurred due to gross misconduct, the employer is not obliged to give the required notice, and therefore payment in lieu of notice is not required. New legislation has been introduced regarding tips and gratuities, which will be very important in the service industry. The Payment of Wages Amendment Tips and Gratuities Act was signed into law by the President on the 20th of July 2022. The aim of the Payment of Wages Amendment Tips and Gratuities Act provide clarity on the meaning of tips and gratuities and service charges to place tips and gratuities, but not service charges, outside the scope of a person's contractual wage, to oblige employers to display prominently their policy on the distribution of both cash and card, and lastly, to oblige employers to distribute fairly and equitably and in a transparent manner tips that are received in electronic form, that is through debit or credit cards or smartphones. Under the Act, the employer must now have a policy in place displaying in a clear and transparent way how cash tips, card tips, gratuities, and service charges are distributed. It is advised that this is incorporated in the employee handbook. However, customers are also entitled to view the policy. An employer is also legally obliged to produce a written statement detailing the distribution of tips and gratuities. This written statement should be provided no later than 10 days after each distribution of tips and gratuities. All employees should receive a written statement, and both the employer and employees are expected to keep the contents of the written statement confidential. The written statement must at least contain the total amount of tips and gratuities distributed by the employer for the period specified in the statement, and the amount of tips and gratuities distributed to have the employee receiving the statement. The written statement should be circulated to the employee no later than 10 days after the distribution of tips and gratuities. In addition to these two documents, an employer is legally required to display a tips and gratuities notice for their employees and customers to be able to view freely. An employer must also display a contract worker tips and gratuities notice if the business employs such people, specifying whether they receive tips and gratuities. The notice should include where tips and gratuities are distributed to employees, the fashion in which they are distributed, and whether service charges are circulated to employees, and if so, in what way. The notice can be located at the place of work, on the organisation's website, or on any other digital platform hosted by the employer. The Sick Leave Act 2022 came into effect on the 1st of January 2023. The Sick Leave Act entitles employees who have a minimum of 13 weeks continuous service with their employer to 5 days in 2024, 7 days in 2025, and 10 days by 2026. If the employer has a more favourable scheme, they can look for an exemption to the Labour Court. The employee will be required to produce a sick cert from their GP on the first day of absence in order to qualify. The amount of pay will be a rate of 70% of the employee's wages, subject to a maximum threshold of €110. The sick leave entitlement should be reflected in the employment contract. Employers must update staff contracts and should include a sick leave policy to reflect the requirements of the new Act. Where employees have exhausted their sick leave entitlement, or where they have not yet reached 13 weeks service, they can apply for illness benefit from the state as long as they have adequate PRSI contributions. In this case, the first 3 days of illness are considered waiting days, so no payment will be given. You must have 26 weeks of PRSI contributions paid in the relevant tax year and 26 weeks of PRSI contributions paid in the tax year immediately before the relevant tax year to claim illness benefit. The relevant tax year is the second last complete tax year before the year in which you claim for illness benefit. For example, if you make a claim for 2022, the relevant tax year is 2020. Remember, the purpose of the legislation around payment and deductions to payments for employees is to ensure employees are clear on what their payment rates are, what they are being paid, and to ensure they are aware of the breakdown of their payments and any premiums or deductions. Key takeaways from this session include: it was announced in Budget 2024 that the minimum wage and the rates for young persons will increase as of the 1st of January 2024. Statutory sick pay entitlement is scheduled to increase each year, and employers need to update their policy to reflect the Act and update all staff contracts. The need to ensure you have a clear policy around tips and prepare the necessary tips and gratuities statement documentation for employees and for your own record management. For further guidance and information on how to fulfil your employer obligations, they are available in the additional resources and the other videos in this suite. For more information on the legislation, you can visit the government website.